commentators.
Yeah, so I'll start. So first of all, thank you. That's really very interesting data, and it's great to hear that you're going to be doing this next phase of the study, because I think the next phase really does touch upon the issue of why are we seeing these differences in invalidation rates. And you mentioned that if you put your patent in litigation, you're sort of fair game, if you will. But I think in litigation, there's a better understanding of what the rules of the road are, and within post-grant, the concern is, okay, you have this very limited, in some respects non-existent right to amend, but you're subject to a broadest reasonable interpretation claim construction standard. Combined with that, there's a perception that there are asymmetries in terms of your ability as a patent owner to put forward evidence, the kind of evidence you can put forward. There have been restrictions on page limitations. I know some of that will be addressed in the PTO's rulemaking package. So again, it all sort of fuels this perception that the rules of the road are kind of tilted against patent owners in inter partes. In addition, a preponderance standard versus a clear and convincing standard. I mean, obviously that's important as well. So I do think, comparing survival rates is important, but really also understanding how are these differing procedural rules impacting a patent owner's ability to survive inter partes review. I think that's a really critical next step. The previous inter partes re-exam process, and again, I remember having this conversation during the AIA negotiations, it was really at the time perceived as an opportunity to kind of refine, narrow your claim. So even though the original claim might not survive, you survive with an amended claim. You survived with something. And the fact that you're now seeing a much heightened risk of surviving with nothing, I think is a really fundamental difference that needs to be taken into consideration. And obviously, if that's improving quality, that's fine. But if there are sort of due process fairness issues that are leading to that result, that's obviously quite a different dynamic. Going back to Todd's question about post-grant review, I will say that post-grant review, and again, it's early days, so we don't know, but it really was perceived as that sort of initial quality check against a patent that's just come out of the PTO. And I do take on board, Suzanne's comments that how do you monitor for the thousands and thousands of patents? But the expectation was that at least within your field, you would have that opportunity on a much broader range of validity grounds to kind of institute that initial quality check. And we'll see if that does in fact play out. But again, all of this sort of leads to the question of what are the goals of a post-grant system, whether it's inter partes review, post-grant review, covered business method patent program. I agree with you that the goal should be to enhance quality, but in order for that goal to be achieved, we also need to take care to make sure that the process is fair. And so I think that has to be part of the conversation and part of the data gathering exercise as well.
I think it's important to keep in mind when talking about IPR to remember that patent owners can always put their patent into re-exam, right? And that is a procedure that's better designed for amending claims and getting those narrower claims out, and that ability is always there. I like that. I love that you're going to be looking at the feedback loop of why are these patents being invalidated, and that Alan's team at the PTO is doing that also, because one of the most exciting things I think going on in the patent world right now is the PTO's initiative around patent quality, and we've got to do a better job of getting it right the first time out. As useful as PGR and IPR can be for patent quality, keep in mind what we're doing is issuing invalid patents without putting a lot of resources into them up front when you think about the prosecution costs, and then depending on productive private companies to spend hundreds of thousands of dollars to clean up that mistake. Overall, that's not the best approach for a patent system that promotes innovation. It's what we need to do right now, but hopefully we'll get to a good place long term.
I think I was at a presentation made by someone from the PTAB before, and some interesting, I think, data was presented. It wasn't presented today, but that showed that the amendment statistics that you hear about in IPR stuff are really nowhere near as draconian as what they sound like. But the point I wanted to make is I think it's a pretty radical thing to have amendments in an IPR because there's no examination, right? These aren't examiners. They're not searching the prior art. They're not people skilled, in the art. To have patent claims come out of a process like that would be, a really fundamental and radical change to the system that all patents that we usually have now have gone through. And, they would be deciding it based on, basically legal people, not examiners, on, motions and stuff kind of put before them, as opposed to the whole process that you have during normal examination. And then, I do agree. I mean, one of the points, the ex parte re-exam process is always there, and you can always put your patent into, re-exam and seek, all kinds of claims. I mean, I have to say, anytime you put a patent in an ex parte re-exam, that process is very much tilted in favor of patent owners. And, oftentimes what happens is, 150 new claims are added, right? And you're facing, and they take all the prior art and they dump everything in there, and now you've got 10 pages of prior art, that have all supposedly been considered by the examiner, and yeah, okay, there's a final rejection made. You're thinking, all right, 7 102 rejections, kind of made or whatever. And then magically there's the post-final examiner interview, right? And then all of a sudden, all claims confirmed, right? And no one has any idea what happened or why, right? So, I think some if we're going to talk about fairness and that kind of stuff, you would need to look at some of the ex parte kind of practice too.
Well, I think that the accumulation of numbers and hard facts is very beneficial, short-term and long-term. I hope Sean and the others will continue, and certainly will have increasing benefits from that. It's important, nevertheless, to remember that in the end, human psychology matters as much as hard facts and figures. Market effects on the incentives for investment within companies or by outside investors, as I mentioned earlier, is a very important effect that is a little harder to measure, but in the end, maybe the most important of all. But even beyond that, there are cultural, what I'll call cultural changes that derive from what's going on in the courthouse and in the patent office. So, for example, David Kapos and I were involved in trying to assist a company in creating a New York Stock Exchange kind of entity for the trading of patent license rights. And it totally collapsed because despite the quality of the portfolios offered for licensing and the very low terms and the amnesty that went along with the purchase of patent rights, every single one of the prospective licensees thought it was a good business proposition, but when they talked to their outside counsel, in every one of dozens of cases, their outside counsel told them, do not negotiate, do not license, wait and see if you're sued. If you're sued, call us. We'll defend you either in the patent office or the courthouse or both, and therefore don't worry about the issue of whether you infringe or whether you think the patent is valid. Don't worry about the business benefits that taking a license might bring you, because we're telling you you don't need to, so just hang tough. So the exchange totally collapsed. We did some further investigation to see whether it was just a skewed sample of potential licensees. So we talked to a whole bunch of outside litigators not representing the licensees, and they all said exactly the same thing. We advise almost all our clients, don't license, don't negotiate. The world has changed. Hang tough. Wait to see if you're sued. If you're sued, call us. So what I like to call the honor system, whereby, for example, in the 90s, IBM was able to license hundreds of thousands of patents to innumerable licensees for several $billion a year in revenue. So it was a very big program. No litigation. That was the honor system. Now the honor system is gone. Now it's a street fight in the courthouse for those who can afford to litigate. So we have to be very mindful of cultural changes and attitudinal changes and advice being given behind closed doors by lawyers to all sorts of corporate interests, because in the end, that may be the most important dynamic going on at all. It doesn't diminish the value of the numbers that are being presented here today, which are very useful, but it's part of the bigger picture that you have to keep in mind if you're going to really understand how the overall system works.